Hello friends, this is Dr. Sumiti Ahuja and I am Assistant Professor from Faculty of Law, University of Delhi. Force majeure. It means basically force majeure relieves one or both parties from liability to perform contract obligations or contractual obligations when performance is prevented by an event or circumstance beyond the party's control. You must be thinking that it is almost similar to what we just studied in doctrine of frustration or impossibility of performance under section 56 part 2. But just understand that it says, we will come to the difference, but let us just see further. Typical force majeure event are fire, flood, civil unrest or terrorist attack. Force majeure is a term used to describe a superior force event. So, the interpretation of the term force majeure is superior force. Purpose of a force majeure clause is twofold. First is it allocates risk, and second is puts the parties on notice of events that may suspend or excuse service, right. So, two things, allocates risk and puts the parties on notice of events that may suspend or excuse the service. That is, say for example, so this type of clause is commonly, popularly if I may say, known as FMC or FM clause, you can say, force majeure clause. In today's times, in the commercial contracts, you will generally find the presence of FM clause, that is the force majeure clause. Now, let us see impossibility of performance, that is section 56 part 2 vis-a-vis force majeure clause. So, what do we mean? Are we trying to say that there is some kind of a difference between the two? Are these two concepts of impossibility of performance as enshrined under section 56 part 2 different from what we just read in the previous slide, force majeure clause? So, 2 points I have highlighted here. While the doctrine of frustration is a common law principle, or you can say the impossibility of performance, this concept which has been incorporated under section 56, as we had discussed in the one of the first sessions of ours, that majorly the provisions of the Indian Contract Act have been taken from the common law principles. So, that is why here, while the doctrine of frustration is a common law principle, force majeure clause is a creation of contract, because force majeure clause is something which you have to incorporate in your terms of the contract. Force majeure is a contractual remedy, that is, parties have incorporated, parties have to, in order to utilize this remedy, in order to make use of that remedy, the parties have to incorporate it under the contract. That is why force majeure is a contractual remedy, and the terms and conditions constituting force majeure clause are decided by the parties prior to the execution of the contract. That is because that is why I am saying you have to incorporate it under your contract, right. So, it becomes important that parties do incorporate such a clause in their respective contracts. Now, although in English law these cases are treated as cases of frustration, in India they would be dealt with under section 32 of the Indian Contract Act, which deals with contingent contracts or similar other provisions contained in the act. Now, let me briefly tell you what contingent contracts are. Now, contingent means, and more specifically section 32 of the Indian Contract Act deals with enforcement of such kind of contracts, the happening of the taking place of which is dependent on happening of a particular event. So, when we say contingent contracts and we are trying to relate it to, somehow related to this force majeure, what we are trying to say is that we have incorporated in the contract, we have incorporated a force majeure clause in the contract, that if the situation like fire, flood, civil unrest or say terrorist attacks or say earthquake, such kind of thing takes place, then the party will be absolved from his or her liability under that contract, right. Now, contingency means that we have stated that if such kind of a situation happens or if such kind of an event takes place, then the parties will be absolved from their liability under the contract, right. That is why contingent, because happening of a particular thing, that is absolving of liability of parties under the contract, it is dependent on happening of a event which is force majeure, right. Thank you everyone. With this we conclude with this session, 8th session on discharge of contract. Thank you.